The idea of going to Serbia was to meet with stakeholders in the whistleblower sphere. And we typically met with NGOs, a number of them. We met with judiciary and government officials. And the idea was to get this perspective across the board to find out how they view whistleblowers, how they treat whistleblowers, how does the judiciary meet with the needs of the whistleblowers, and how do they address those challenges there. So that was Serbia. Then we went to Lithuania, and our primary focus there was to attend the International Anti-Corruption Conference. And that was over 3 or 4 days. And it was a fantastic opportunity to meet with individuals and organizations that actively are involved with anti-corruption strategies and activities. And a specific focus for us was the focus on whistleblowers.
What we learned during this journey is that retaliation is actually against whistleblowers is a global phenomenon. In South Africa, for instance, 48% of people who blew the whistle in 2024, or the first part of 2024, have been retaliated against. Okay, so in France, in a previous survey that was done, it was 60% of people. In India, also according to a recent study, it's 61%. So although we don't have statistics available for the countries that we visited during this learning journey, there is research that tells us that retaliation is just, it's phenomenal. The difference, however, with South Africa is that the retaliation in the rest of the world seems not to be as violent as the case here in South Africa, where we know that our whistleblowers, or many whistleblowers, have been assassinated.
We rank very high in terms of crime and violence. The number of deaths, the number of murders, across the board, you can just look at our statistics, and we're very high in terms of internationally. So it is not strange to find that the whistleblowers fall into that category as well. And therefore it's dangerous for them, and we've got to make sure that we have mechanisms in place to secure them. We must educate them in regarding how to maneuver, how to deal with threats, be alert, take care of your family, make sure you're secure in your environment. Those kind of things we also take care of.
We learned that in Serbia, one of the most significant national whistleblowers was a judge. And once he had blown the whistle and discovered the many antagonisms that a whistleblower typically experiences when they go up against a major entrenched system with major entrenched powerful interests, he discovered that there are many kinds of retaliatory action that a whistleblower can experience. So he also discovered that his colleagues didn't understand that syndrome of abuse that whistleblowers often get, and likened it to the kind of pattern of abuses that women experience in typical domestic violence cases. He then said it is better that prosecutors do not lose whistleblower cases because they have got blind spots as to what is going on with the cycle of abuse. It's better if they are educated on this, but also his colleagues on the bench in Serbia were likely to come to more just outcomes and richer rulings if they were educated about this whole syndrome of patterns of abuse that are experienced by whistleblowers and the psychosomatic effects that it has on them. So when we heard that training makes a difference to the court outcomes, and court outcomes make a difference, if you have many positive outcomes, then it encourages whistleblowing, because people think, okay, no, the courts can protect me. So when we heard that, we thought, bingo, this is something to implement back home.
What we found interesting in Serbia when we met with the judiciary is that they are specialized courts. Judges are specially trained on the legislation and they get certificates for that, so you get dedicated courts to deal with whistleblower whistleblower issues.
So if I blow the whistle, I can immediately ask for protection from the court. And then the court will inform my employer, that I may not be retaliated against for blowing the whistle. In South Africa, of course, we know it's completely different, and in many other countries as well. You blow the whistle, you are protected by law, but can only approach the law after retaliation has occurred. Whereas in Serbia and Slovakia, you can approach the courts before retaliation can even occur, and you're immediately protected.
We saw in Serbia that the states and the civil society work together in a lot. Even when they were drafting their legislation, the civil society was very involved in the drafting. The civil society also assists in training of the judges and the prosecutors. They provide training materials.
What is coming more to the fore in whistleblowing protection laws is that the onus of proof to show that I, as an employer, did not retaliate against a whistleblower rests on the employer. If you retaliate against a whistleblower and the whistleblower takes you to court, you must prove that you didn't retaliate. Whereas in South Africa, for instance, and in many other countries still, the onus of proof is on the whistleblower. One thing in terms of the cultures that was very interesting to learn is the fact that, for instance, in Mexico, they have changed the name from whistleblower to someone who alerts, and that is because of the negative perception of whistleblowers. Build a positive picture around blowing the whistle, and create awareness in the public. Basically in societies, to say, why is it important to blow the whistle?
Most countries have the protection under labor law, like majority of the country. But we have seen that in South Africa, labor law protection is not doing us justice, because the legislation that deals with whistleblowing specifically deals with employee and employer relationship. And now that causes a problem when a person who's not in that relationship whistleblow, because in terms of that legislation, they are not protected. So that is what the discussion paper that was published last year by the Department of Justice is trying to ascertain. How do we now solve this problem?
The Serbian and Slovakia model, I think, can be replicated in South Africa, where you have an independent agency that receives reports, that makes sure that the reports are investigated, and make sure that the whistleblowers are protected. So we should also look at a model where we can actually provide them with legal advice, pro bono, psychological assistance, medical assistance where they need it, and then of course security, and then ultimately financial assistance.
South Africa is on par with other countries when it comes to whistleblowing legislation. For example, you will see that the PDA is similar to the PIDA, which is a UK legislation. However, South Africa is looking to go further than what other countries are doing. For example, you'll see with the publication of the discussion paper that was published by the Department of Justice last year in June, that South Africa is proposing that whistleblower protection be expanded to human rights protection as well. So South Africa is on par, but we're looking to go further.
Well, the EU directive was really a propeller of a lot of the thinking about legislative reform for whistleblower protection, because it introduced a new framework for working with whistleblowers. The first thing that the EU recommends is that the onus or the burden of proof in a court case shouldn't be slanted against the weaker party, but it should be borne by the party with greater means. So we went to see the journalists stroke whistleblowers who were very influential in the crafting of the European directive. And so when they started telling us how they moved from their trauma to helping their society to craft a new set of policies, a new set of principles, and new laws for each country. Well, each country has got some liberty in implementing the European directive, but they pretty much have the same approach. So it's a guided approach. So when we heard that they had helped their own continent to change the laws protecting disclosures, we then resolved, and we have done some work on this, not only to have a conference here at home to speak to parliamentarians, but to speak to the parliamentarians of the African Union and its parliament, as well as to speak to the architects of the policies of the AU, so that we can converge and cohere around a set of legislation or a set of legislative principles that AU countries can adopt or attempt to implement in order to protect whistleblowers.
I think for me, the activism from civil society as we met civil society organizations was quite striking. Also for me is the ability for civil society organizations to work towards, together with government and other structures and law enforcement agencies without feeling the tensions and the constructive tensions, and working towards the same goal, working towards the same mandate, and which is obviously the developmental goal of building capable states and ethical states. So the ability of certain countries to follow the UN Convention and then roll this out in consultation with civil society organizations and other sectors of society, working alongside business organizations. And I think this kind of integrated approach gives solidarity to the movement and obviously gives confidence to the whistleblower that I can enter into this in a free space, not be judged, and be able to raise the issues that I want to raise, and that there is transparency that I will meet along the way.